Reading out of the Mutual Holding Companies Act on paper page 704 of the old text of the Reference Guide to Regulatory Compliance. I really can't believe this, but there's a Savings and Loan Holding Company Act reading coming right up after this one. And really looking forward to the whole 15 or so pages of that. Okay, it's only 10, but still, this is really rather excessive. Indemnification, subpart H. This came right after the part about voluntary supervisory conversion and the approval of that by the Fed. Indemnification yet is probably independent of that section. Within the liquidation and conversion of mutual holding companies, part of the mutual holding companies regulations I'm reading right now. Under indemnification, it says that a mutual holding company must indemnify its directors, officers, and employees for any amount for which that person becomes liable under a judgment, and reasonable costs and expenses, including attorney's fees actually paid or incurred by defending that person or in enforcing his or her rights if that person attains a favorable judgment in such enforcement action. 2. Indemnification is made available only if the final judgment on the merits is in that person's favor. And B, in the case of a settlement, a final judgment against him or her, or a final judgment in his or her favor other than on the merits, if a majority of the disinterested board of directors determine that he or she was acting in good faith within the scope of his or her employment or authority as he or she could have reasonably perceived it under the circumstances. 3. Under indemnification, no indemnification will be made unless the mutual holding company provides notice at least 60 days in advance to the FRB of its intention to make such indemnification. 4. A mutual holding company may obtain insurance to protect it and its officers and directors from losses arising from claims against them. 5. No mutual holding company may obtain insurance to protect it or its officers and directors from willful or criminal misconduct. And 6. The board of a mutual holding company may authorize the payment of expenses if they are in connection with a matter that a majority of the board believes may ultimately be entitled to indemnification. Employment contracts. Subpart I, under liquidation and conversion of mutual holding companies. A mutual holding company may enter into an employment contract with its officers and employees in accordance with this section of Regulation MM. Employment contracts may be entered into if they would constitute an unsafe or unsound practice. And 3rd, employment contracts must provide, among other provisions, the following. A through E. The mutual holding company's board may terminate the officer or employee's employment at any time, but unless a termination is for cause, it will not prejudice any employee's right to compensation or other contractual benefit. Termination, in parentheses, for cause includes termination due to the employee's personal dishonesty, incompetence, willful misconduct, violation of law, breach of fiduciary duty, or failure to perform stated duties. And parenthesis, letter B, if the officer or employee is prevented from participating in the operations of the holding company due to an order under certain provisions of the Federal Deposit Insurance Act, and the holding company's obligation under the contract will be suspended period. Letter C, if the charges under the FDI Act are dismissed, the holding company may, at its discretion, pay the employee all or part of the compensation withheld, reinstate the officer or employee, and if the charges are not dismissed, the holding company may terminate the contract, and E, the contract may terminate upon bankruptcy of the mutual holding company. J, subpart J of the liquidation and conversion of a mutual holding company is subsidiary holding companies. A mutual holding company may establish a subsidiary holding company as a direct subsidiary to hold 100% of the stock in its savings association subsidiary. 2. The aggregate amount of outstanding common stock of the association owned or controlled by persons other than the subsidiary holding company's parent at the close of the proposed issuance must be less than 50% of the subsidiary holding company's total outstanding common stock. 3. Charters of subsidiary holding companies of mutual holding companies must be in the form of the model in Appendix B to Regulation MM. 4. Optional provision to limit minority stock ownership. A subsidiary company holding company that emerges in its initial minority stock issuance after October 1st of 2008 may, before it conducts its initial minority stock issuance at the time of the minority stock issuance or at any time during the succeeding 5 years, include in its charter the following provision, provided it discloses the fact that it may adopt such a charter provision in its offering materials. Beneficial ownership limitation. No person may directly or indirectly offer to acquire or acquire the beneficial ownership of more than 10% of the outstanding stock of any class of voting stock of the subsidiary holding company held by persons other than the subsidiary holding company's mutual holding company parent. This limitation expires on insert date within 5 years of minority stock issuance and does not apply to a transaction in which an underwriter purchases stock in connection with a public offering or a purchase of stock by an employee stock ownership plan or other tax-qualified employee stock benefit plan that is exempt from the approval requirements under Section 238.12A7 of the board's regulations. So that's a board regulation, surprisingly. Okay. In the event a person acquires stock in violation of the section, all stock beneficially owned by such person in excess of 10% of the stock held by stockholders other than the mutual holding company will be considered excess shares and will not be counted as stock entitled to vote and will not be counted as voting stock in connection with any matters subject to the stockholders for a vote. Charter amendments. A, must be approved by the board of the subsidiary holding company. B, if proposed amendment would render or discourage a merger, proxy contest, the assumption of control by a mutual account holder, or the removal of incumbent management or involve a significant issue or law or policy, then it must be submitted to the FRB for approval. C, if the proposed amendment does not do any of those things, it must be submitted to the FRB at least 30 days prior to the date the proposed amendment is to be mailed for consideration by the subsidiary holding company's shareholders. It will be automatically approved 30 days from the date of filing, provided the mutual holding company has met all of the requirements and unless the FRB notifies the subsidiary holding company that it is rejected or that requires an application. Bylaws. The board of the subsidiary holding company must adopt bylaws at its first organizational meeting. All bylaw amendments must be submitted to the appropriate reserve bank for approval if it would render more difficult or discourage a merger, proxy, assumption of control by a mutual account holder, or the removal of incumbent management. Bylaws that would involve a significant issue or law or policy or are inconsistent with the requirements of Regulation MM must be submitted to the appropriate reserve bank for approval. D, if the amendment does not have any of the above provisions, it must be submitted to the Reserve Bank at least 30 days prior to its effective date, at which time it will be effective unless the FRB notifies the holding company that it has been rejected or that it requires an application. Issuances of stock by subsidiary holding companies. No subsidiary holding company may issue stock to persons other than the mutual holding company parent unless it obtains advance approval of each such issuance from the Fed. Fed approval of the issuance. The Fed will approve any proposed issuance that meets the criteria. The issuance is made pursuant to a stock incentive plan that meets the requirements of this registration. The stock issuance plan is consistent with the terms of the subsidiary holding company's charter, including the type and amount of stock that may be issued. 3. The stock issuance plan would provide the subsidiary holding company, its mutual holding company parent, and any savings association subsidiaries with fully sufficient capital and would not be inequitable or detrimental to any of these entities or their members. Letter C. The proposed stock price or price range is reasonable in the opinion of the FRB. Is required for issuances of stock by the subsidiary holding company. D. The aggregate amount of outstanding stock of the subsidiary holding company that is owned or controlled by persons other than the parent mutual holding company will be less than 50% of the total outstanding stock of the subsidiary holding company unless the subsidiary holding company was a stock holding company when it was acquired by the mutual holding company. A subsidiary holding company may issue any amount of preferred stock to persons other than its mutual holding company parent as long as it is consistent with any other applicable laws and regulations. E. Under issuances of stock by a subsidiary holding company, the subsidiary holding company furnishes the required information to the FRB. F. The proposed stock issuance meets the FRB convenience and needs standards. And G. The proposed issuance complies with all other applicable laws and regulations. Okay, so 8 is the restrictions on offerings. No representations may be made in connection with an offer that the price or the stock has been approved, disapproved, or endorsed by the FRB. B. The sale of minority stock of the subsidiary holding company to be made under the minority stock issuance plan must be completed as promptly as possible, within 45 calendar days after the last day of the subscription period, unless extended by the FRB. C. In the offer or sale of stock issued under this regulation, no person may employ any device, artifice, or scheme to defraud, make any untrue statement of a material fact, or omit to state a material fact necessary to make statements not misleading. And 3. Engage in any practice which operates as a fraud upon a purchaser or seller. D. Prior to the completion of a stock issuance, no person may transfer or agree to transfer the ownership of the stock to any other person. Prior to the completion of a stock issuance, no person may offer or make an announcement to offer to purchase any stock to be issued or knowingly acquire any such stock in excess of the maximum purchase limitations established by the stock issuance plan. F. All stock issuances pursuant under this regulation must comply with the FRB securities offering regulation. 2. Provide that the offering be structured in a manner similar to a standard conversion under the FRB conversion regulation, including the priority rules accorded to members. G. A subsidiary holding company of a mutual holding company may issue stock as part of a stock benefit plan to any insider, associate of an insider, or tax qualified or non-tax qualified employee stock benefit plan of the holding company or its subsidiary without including any such priorities, including the purchase priorities. H. As part of a reorganization, a reasonable amount of shares or proceeds may be contributed to a qualified charitable organization, provided that the contribution does not result in any taxes on excess business holdings under the Internal Revenue Code. 9. The procedural and substantive requirements of the FRB stock conversion regulation will apply to all mutual holding company stock issuances and subsidiary holding company stock issuances under this section, unless it is clearly inapplicable as determined by the FRB. 10. Contents of the stock issuance plans. A. Mandatory provisions of the plan. I. Each plan must contain a description of all significant terms of the proposed stock issuance, must attach the proposed stock certificate and proposed stock order form and any other agreements concerning the rights of the stockholders. 2. Each plan must provide that A. The stock will be sold at the total price equal to the estimated pro forma market value based on the independent evaluation. Period. B. Any total amount of outstanding common stock owned or controlled by persons other than the subsidiary's mutual holding company parent at the close of the issuance must be less than 50% of the total outstanding, although this provision may be omitted if the issuance will be conducted by a subsidiary holding company that was in stock form when acquired by the mutual holding company parent. C. All employee stock ownership plans or other tax-qualified employee stock benefit plans must not encompass in the aggregate more than either 4.9% of the outstanding shares of the subsidiary holding company's common stock or 4.9% of the subsidiary holding company's stockholders' equity at the close of the issuance. D. All ESOPs and management recognition plans must not encompass in the aggregate more than either 4.9% of the outstanding shares of the subsidiary holding company common stock or 4.9% of the subsidiary holding company's stockholders' equity at the close of the proposed issuance. However, if the subsidiary holding company's tangible capital exceeds at least 10% at the time of plan implementation, the FRB may permit the ESOP and MRPs to encompass in the aggregate up to 5.88% of the outstanding common stock at the close of the proposed issuance. Letter E. All MRPs must not encompass in the aggregate more than either 1.47% of the common stock of the subsidiary holding company or 1.47% of the subsidiary holding company's stockholders' equity. However, if the subsidiary holding company's tangible capital is at least 10% at the time of implementation of the plan, the FRB may permit MRPs to encompass in the aggregate up to 1.96% of the outstanding shares of the subsidiary holding company's common stock or 1.96% of the subsidiary holding company's stockholders' equity. F. All stock option plans must not encompass in the aggregate more than 4.9% of subsidiary holding company's outstanding common stock or 4.9% of the subsidiary holding company's stockholders' equity. G. An ESOP or MRP or an option plan modified or adopted no earlier than 1 year after the close of the proposed issuance may exceed the percentage limitations of the regulation subject to the following requirements. 1. All such common stock must be acquired in the secondary market, and 2. Such acquisitions must begin no earlier than when such plan expansion is permitted to be made. H. The aggregate amount of common stock that may be in all option plans and MRPs or acquired by all insiders of the subsidiary holding company and subsidiary savings association must not exceed the following percentages of common stock or stockholders' equity held by person other than the subsidiary holding company's mutual holding company parent at the close of the proposed issuance. And we're back to the table of the percentage of the stock that can be owned by officers and directors based on institution size, and this incrementally goes down by 1 percentage point as the institution size rises from 50 million in each increment. So for institutions 50 million or less, officers and directors can own 35% of the stock, common stock. For institutions 50 million to 100 million, officers and directors may only hold up to 34%, and so on and so forth, in increments of $50 million all the way until 25% ownership is allowed for institutions that are higher than $500 million. Letter I, these percentages may be exceeded if all stock acquired by insiders and associates of insiders or awarded under all MRPs is acquired in the secondary market at least 1 year after the close of the issuance. And J, in calculating the number of shares held by insiders and their associates shares awarded but not delivered under an ESOP, MRP, or option plan that are attributable to such persons are not counted as being acquired by such person. The amount of common stock that may be encompassed under all option plans and MRPs must not exceed, in the aggregate, all option plans and MRPs aggregate 25% of the outstanding common stock held by persons other than the mutual holding company parent. We just went to like Roman numeral 3 all out of nowhere. Okay, Roman numeral 3 under A, mandatory provisions of the plan. Roman numeral 4, the issuance must be conducted in compliance with the FRB securities offering regulation. Roman numeral 5, the sales price of the shares must be a uniform price determined in accordance with this regulation. Roman numeral 6, if at the close of the stock issuance the subsidiary holding company has more than 35 shareholders of any class of stock, it must promptly register that class of stock under SEC Act of 1934 and undertake not to deregister such stock for a period of 3 years. Roman numeral 7, if at the close of the stock issuance the subsidiary has more than 100 shareholders in any class of stock, the subsidiary must use its best efforts to encourage and assist a market maker to establish and maintain a market for that class of stock. B, list that class of stock on a national or regional securities exchange or on NASDAQ quotation system. Roman numeral 8, for a period of 3 years following the proposed issuance, no insider of the subsidiary holding company or his or her associates may purchase any subsidiary holding company stock without the prior written approval of the Fed, except from a registered broker-dealer. However, this restriction does not apply to A, negotiated transactions involving more than 1% of outstanding stock in a class of stock, and B, purchases of stock made by and held by any tax-qualified or non-tax qualified employee stock benefit plan of the subsidiary holding company, even if such stock is attributable to insiders of the subsidiary holding company or their associates. Roman numeral 9, stock purchased by insiders of the subsidiary holding company and their associates in the issuance shall not be sold for a period of at least 1 year following the date of purchase, except in the case of death of the insider or associate. X, Roman numeral X, 10, concerning restricted stock A, B, or C. A, each stock certificate must bear a legend giving appropriate notice of such restriction. B, appropriate instructions must be issued to the transfer agent regarding the applicable restrictions on transfer of such stock. And C, any shares issued as a stock dividend stock split with respect to any such restricted stock shall be subject to the same restrictions as apply to the restricted stock. Roman numeral 11, the subsidiary holding company will not offer or sell any of the stock proposed to be issued to any person whose purchase would be financed by funds loaned directly or indirectly by the subsidiary holding company. Roman numeral 12, if necessary, the subsidiary holding company's charter will be amended to authorize issuance of the stock. Roman numeral 13, the expenses incurred in connection with the issuance must be reasonable. Roman numeral 14, the stock issuance plan. It proposes part of the reorganization plan may be amended or terminated in the same manner as the reorganization plan. Otherwise, the plan must provide that it may be amended by the subsidiary holding company's board of directors as a result of comments from regulatory authorities or otherwise prior to approval of the plan by the FRB and at any time thereafter with the FRB concurrence. Roman numeral 15. Unless the extension is granted by the FRB, the stock issuance plan will be terminated if not completed within 90 days of the date of FRB approval. Roman numeral 16. The subsidiary holding company may make scheduled contributions to a tax-qualified employee stock benefit plan provided that the contributions do not cause the subsidiary holding company to fail to meet its capital requirements. Letter B. Optional provisions of the plan. When subsidiary holding companies issue stock. The stock issuance plan may provide that 1. Roman numeral 1. If the stock issuance is part of a reorganization plan, the stock offering may be commenced concurrently with or at any time after the mailing to the members of the reorganizing association and any acquiree association of a proxy statement. Roman numeral 2, insignificant residues of stock not sold in the offering may be sold in such other manner as provided in the stock issuance plan with the FRB's approval. Roman numeral 3, the subsidiary holding company may issue and sell in lieu of shares of its stock units of securities consisting of stock and long-term warrants or other equity securities. Roman numeral 4, the subsidiary holding company may reserve shares representing up to 10% of the offering for issuance to an employee stock benefit plan. Number 11, shareholder meetings under subsidiary holding company. Annual meetings. Subsidiary holding companies must hold annual meetings for the purpose of electing directors and transacting other business. Roman numeral 2, meetings must be held within 150 days of the close of the holding company's fiscal year. Roman numeral 3, special meetings may be called by the board of directors or upon the request of holders of 10% or more of shares entitled to vote at the meeting. Letter B, notice of meetings. Roman numeral 1, written notice of the place, day, and hour of the meeting and the purpose must be delivered not fewer than 20 nor more than 50 days before the meeting date at the direction of one of the board members or other natural persons calling the meeting to each shareholder of record entitled to vote at the meeting. Roman numeral 2, the board must determine a date in advance of the meeting by not more than 60 and not less than 10 days prior to the meeting date to determine the shareholders entitled to notice and entitled to vote. Roman numeral 3, at least 20 days prior to the meeting, the officer having charge of the stock transfer books must make a complete list of the stockholder and record entitled to vote at such meeting along with the address and number of shares owned. This list must be kept on file at the home office of the subsidiary holding company and will be subject to inspection by any shareholder of record during the time of the meeting. And Roman numeral 4, the majority of shares will constitute a quorum at the meeting of shareholders. Letter C, shareholder voting. Roman numeral 1, a shareholder may vote in person, by proxy, or by a duly authorized attorney in fact. Roman numeral 2, proxies may be given telephonically or electronically as long as procedures for verifying the identity of the shareholders are used. Roman numeral 3, treasury shares and shares held by another corporation if a majority of the shares entitled to vote for the election of directors of such corporation are held at the subsidiary holding company may not be voted or counted in determining the total number of outstanding shares at any given time. D, nominations and new business. Nominations for directors and new business submitted by shareholders will be voted upon at an annual meeting if such nominations or new business are submitted in writing at least 5 days prior to the meeting. Board of Directors, number 12, the business and affairs of the subsidiary holding company must be under the direction of the Board of Directors. B, the board must annually elect a chairman. C, the bylaws must set forth a specific number of directors, not fewer than 5 nor more than 15, unless a higher or lower number is authorized by the FRB. D, regular meetings of the board must be held. E, the majority of directors will constitute a quorum. F, any vacancy occurring on the board may be filled by the affirmative vote of a majority of the remaining directors. G, directors may be removed for cause at a meeting of shareholders called for that purpose. H, the board may designate committees from among its members, including an executive committee or one or more other committees, each of which may act with the full authority of the board. I, written notice of special board meeting must be given at least 24 hours in advance. Attendance by any member is considered to be the waiver of notice of the meeting. J, any action that could be taken at a meeting may be taken without a meeting if consent in writing setting forth the action to be taken as signed by all directors. K, a director who is present at a board meeting at which action is taken will be presumed to have assented to the action taken unless his or her dissent or absentation is entered in the minutes of the meeting or unless it is filed with the secretary of the board. L, the subsidiary holding company may provide an age limitation on directors in the bylaws. Number 13, officers. A, officers of the subsidiary will include a president, one or more vice presidents, a secretary a treasurer or comptroller. The treasurer, secretary, and comptroller may be the same person. A vice president may also be either the secretary or the treasurer or comptroller. Letter B, all officers will be elected by the board. Letter C, officers may be removed by the board, but such removal, other than for a cause, will be without prejudice to the contractual rights of the officer. D, subsidiary holding companies may impose an age limitation on officers, but it must comply with all applicable state and federal laws. Number 14, certificates for sale and their transfer. A, the board will determine the form of certificates or shares for the company. B, certificates will be signed by the CEO or other officer designated by the board. C, shares must be consecutively numbered and the name and address of the share owner will be entered on the stock transfer records. D, share transfers will be recorded on the stock transfer records. Number 15, annual reports. A, annual reports must be mailed within 130 days after the end of the fiscal year to each stockholder entitled to vote. B, annual reports must include financial statements that satisfy the requirements of Rule 14A-3 of the Securities Exchange Act. C, annual reports must be signed by the chairman of the board, the president, and the vice president, and submitted to the appropriate reserve bank. D, subsidiary holding companies must maintain accurate books, records, and committee minutes. E, shareholders have the right to review the records of the subsidiary holding company. And that completes the section on mutual holding companies. Believe it or not, there's only 3